I'm getting divorced. Will I have to share legal custody of my kids? Hi, I'm Bill Farias, founder of Farias Family Law. I just got this question yesterday. We met with a gentleman who is moving toward divorce, has a couple of little ones, and he wants to know, will I be able to get shared legal custody? Am I going to be able to be involved in making major decisions for these kids on healthcare, schooling, and so forth? So the way that the courts in Massachusetts handle legal custody is it's sort of the default option in the sense that as long as both parties are reasonably stable, the courts will generally err on the side of awarding shared legal custody to the parents. And the reason for that is that generally it's better for children to have both parents involved than to have just one parent making all of the decisions. But that's just generally, right? Because there are certain circumstances in which it doesn't make sense to have two parents involved. And so I want to talk a little bit about that. So one of these situations is violence. If there is a history of violence, that is something the court has to consider in deciding whether to award shared legal custody. And in fact, there is a presumption that if there is a history of violence, then the perpetrator should not get legal custody. And so if the court is going to sort of go against that, then the court has to make written findings. In other words, explain why in this situation where there is a history of violence is the court awarding shared legal custody. And so violence is a factor that stands out in a shared legal custody analysis. Another is generally whether a parent isn't able to effectively engage in decision making for the child. So that may be a serious substance abuse issue, a serious mental health issue. Usually it's when a person isn't treating and isn't maintaining a substance abuse problem or mental illness that the judge might say that the person, or might find that the person isn't capable of effectively parenting with respect to making major decisions. And so that's another factor, is if you have a parent who is seriously mentally ill, who has a serious substance abuse problem, especially if it's not being treated, a court might err on the side of ordering sole legal custody. Communication is also a factor, right? So if the parents just can't communicate, then in some cases a judge might order sole legal custody. However, generally what the court will try to do is the court will try to find sort of a workaround. So if you have two people who are generally stable and the child would benefit from input from both parents, if these people don't communicate, what the court will first try to do is implement different methods of communication to try to solve that problem. So a good example here is a parenting app. So in many cases, a judge will order the parents to communicate through an app so that everything's documented. There is less confusion and frustration. And so that helps in many cases where people don't get along, but they can at least utilize the app to communicate the essentials and work out their differences. Another tool that the courts use on the issue of communication is they might order a parenting coordinator or a mediator, right? Someone who can help the parties resolve differences so that both parties still have input, but if you need a tiebreaker, then the court will allow the parenting coordinator or mediator to make that decision. And of course, the court is always open to filings for disputes. So if something really can't be worked out, then generally the court is accessible. But the court, in some cases, first expects the parties to utilize these tools to try to work around their communication issues. So The answer to this question about whether you will get shared legal custody is that, first of all, from a macro view, that is the default. So if you are generally stable and interested in your child, then the court will err on the side of shared legal custody or giving you legal custody. But you do have these factors that come into play that the court does consider, and so they are history of violence, right? History of substance abuse and mental illness. Is that substance abuse and mental illness being treated? And you also have communication issues. And finally, history of involvement, right? So this is one that also comes into play. If somebody just hasn't been around for a long time, and all of a sudden they're coming back into the pictures after years of hiatus, then in that case, the court might also order sole legal custody. And maybe if that person is serious about sort of reintegrating into the child's life, legal custody can be sort of re-examined. But at least at the early stages, it sometimes doesn't make sense to give someone who just hasn't been around for a long time shared legal custody, because it might cause conflict and ultimately not be in the best interest of the child. So these are some considerations for legal custody and whether the court would order shared legal custody. If you have any other questions, you can call us 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel, share it with anyone you think might benefit from it, and you can find us on social at Farias Family Law. Thank you. Have a good day.